Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and probate attorney in New York. I received a question and it's about guardianship and I'm going to answer. But first, if you have a question for me, please go to Frank Bruno Law. We set an appointment. I'll give you a free telephone call. We'll speak about your situation. So the question about guardianship was, how many types of guardianship are there? So I'll give you a brief little informational piece about guardianship. There's guardianship of children in the family court, and that's for children up the age of 21. It's a weird little dynamic in the family court. Custody only lasts until a child is 18. A person is considered an adult at 18, but there is guardianship in family court, and that can extend until the child is 21. That's not the type I'm talking about. But if you ask about guardianship, I at least figure I'll mention. There's a guardianship, a 17A guardian, in surrogate's court. That's a different flavor of guardianship, and I'm going to push that one to the side as well. The three types of, so I'll tell you about guardianship in Supreme Court for an incapacitated person, and there's three types. A guardian can be a guardian of the person, a guardian of the property, or guardian of the person and property. Guardian of the person handles the person's affairs of health and personal well-being and living space and how to arrange for bills. That's a guardian of the person. Guardian of the property means the person's assets and income. It could include real property, but otherwise just their financial well-being. And then a plenary guardian, or there can be one person that's the guardian of both person and property. And this if a person really has significant incapacity and they need assistance with all areas of their life. I wrote an article that's going to be posted next week in the Queens County Bar Bulletin about the area of guardians. And the thrust of the article was that there are 4 types of guardianship across 3 different courthouses in New York. We have guardianship in the family court. That's where one person seeks to be the guardian, physical caretaker, a parental role for a child. No money is involved. Then there's the type of guardianship in surrogate court. There's actually 2 of those. An Article 17 guardian and an Article 17A. And the 17 is similar to the guardianship in family court, except it has the additional priority, obligation, the additional power of a guardian being able to handle money. And that's why you would file in the surrogate court to get the jurisdiction over the money. If a child inherited money or was the recipient of a personal injury or a lawsuit, monetary amount, you might use Article 17. Article 17A in the surrogate's court is for a parent of an adult developmentally disabled child. So that's for an adult guardianship, typically parent to child and mental or physical disability. And then finally, the 4th type of guardianship is Article 81. It's in the Supreme Court. And it also is commonly used for one person filing to be the guardian of an adult. The statute doesn't say it has to be an adult. And there are some cases where it was interpreted that it was a child. But overwhelmingly, commonly it's used for an adult. So different types of scenarios. A person gets the adult onset of dementia, Alzheimer's, or a stroke, or some other physical ailment. It doesn't have to be that fact pattern. That is a typical way that it presents. So those are the 4 types of guardianship across 3 courthouses: family court, surrogate's court, and Supreme Court. What should I know about adult guardianship? Guardianship is a serious matter. When you ask the court mission to be a guardian over another person, you're mostly taking on the challenge of overseeing their life. The appointed guardian is responsible for making financial, healthcare, and property management decisions for the individual. You're asking to be the guardian of the person and of the property. The subject of the proceeding at the outset is an alleged incapacitated person. In the state of New York, you can only obtain guardianship if a person is incapacitated. The legal definition. There are two types of guardianship proceedings for incapacitated adults. There's an Article 81 guardianship in Supreme Court and the 17A guardianship in Surrogate's Court. So pursuant to Article 81, that's the New York mental hygiene law, guardianship is used to help appoint a person to manage the affairs of an incapacitated individual. Either there must be reasonable proof that such an arrangement is necessary, or the person must agree. It's a consent decision, consent agreement. When someone is intellectually or developmentally disabled, the guardian will act as a parent. And if an individual is developmentally delayed, then the proceeding would be an Article 17A guardianship. The code for guardianship over the disabled is 17A, and it's in Surrogate's Court. The disability must begin in childhood, a neurological impairment, or something physical, such as autism or cerebral palsy. The language is specific to the guardianship statute is a guardian is requesting to be, it's a petitioner, they're requesting to be the guardian, the person, that's their individual choices and decision, and also a guardian of the property implying financial, not necessarily real property, just money and their monthly. What would you do if you were appointed a guardian? Do we know what a guardianship is? Let me tell you a little bit about that. Guardianship is the legal relationship between a competent adult and an adult that based on their mental ability, their mental status, is not able to properly care for themselves. They have an incapacity of some kind, and the court has observed that because there was an application and there was a hearing, and they determined that another adult should be their guardian. Well, what would you do if you were that person that was appointed as the guardian? Well, the first thing you need to do is read the order of the court. Take a look at what instructions, what guidance, what direction the court has given you. That's number one. The second thing to realize is that it's a great responsibility and you have to file reports. At the outset, you have to file an inventory. That's when, within a prescribed period of time, you have to take a look at the assets of your ward and determine what they are, or write it down and file it with the court. After that initial inventory, that initial accounting, you then have to file annual accountings. Just like we file taxes every year, you have to file annually with the court. You have to remember you have a fiduciary duty to your ward. You have to act in their best interests, safeguard their assets, tend to their both personal and financial life. What else? You should consult with your ward. Even if the person has incapacity, you are definitely required to see the ward a minimum 4 times a year. Most often I see people that either live with their ward or see them weekly, but you need to consult with the ward, take into account their thoughts and feelings and their position on different things. And also, don't limit your ward's social interaction. Allow the ward to have friends, have social events, get out in the fresh air, give vacations to the ward. You really need to do what's in that person's best interest. I'd like to tell you about guardian ad litem in Surrogate's Court. Recently, I was appointed as a guardian ad litem in the Surrogate's Court. Now, the surrogate is the judge in the Surrogate's Court. That's where wills are probated and the affairs of dead persons are resolved, right? Decedent's assets and estate are taken care of in the Surrogate's Court. Outside of New York, many other locations, they call it probate court. Well, the probate process in New York takes place in surrogate's court. Now, a guardian ad litem is appointed in a variety of circumstances. If the beneficiary of a will is a minor and it hasn't been, and they can't speak for themselves in court. If a beneficiary is incarcerated or is disabled or has incapacity or is unknown, like their location is unknown, a guardian ad litem can be appointed to stand in their shoes and to represent. Guardian ad litem is a Latin word for guardian in the litigation. So I was appointed to be the guardian ad litem for a person who had a mental disability. He's presently living in a group home. And the court directed me by order to represent his interests. So there's a number of things that have to take place as the guardian ad litem. Where appropriate, I meet with my ward. I speak to the attorney that's filing the court matter, speak to any other interested person. He gives me some insight into the matter. I review court documents, look at the court record, and that gives me a better handle on what steps I have to take to ensure that my client's interests are protected and preserved. I'd like to speak about how you can provide money to your children that are under 18 years of age. We don't typically leave money to kids except in unfortunate circumstances. So if a parent should pass away while their children are under the age of 18, and the parent can provide for the care for that child. So in that instance, a parent needs to appoint a guardian, and the guardian should be a person that has their similar beliefs in how to raise a child, probably the same religious upbringing, has the same views on whether to go to a public school or parochial school, same thoughts on vaccinations, healthcare issues, what to eat, how to eat, things like that. The guardian will be the caretaker of your child. Now, the person that would control money can be a trustee. The guardian and the trustee don't have to be the same person. And this way you can appoint a good money manager. Now, you never want to leave a child money outright, because if you're under 18, you can't sign, can't own property in your name, at least not conveniently. So you should have a provision in your will for a testamentary trust, or outright keep the asset in a trust in advance of any untimely death. But your will could have a provision for a guardian for the care of your child and a trustee for the care of the money and the financial control. Then you would set up certain guidelines as to what funds, what money the trustee has to give to the guardian to care for the child. If you'd like to talk about this or any other elder law issue, please reach out to me. I have represented children in court more than 100 times, hundreds of times. I have represented and been involved in cases for incapacitated people hundreds of times. As both a planning attorney and an attorney involved in litigation, it allows me to see all aspects of the case, and it makes me a better attorney for planning issues.
Friend, father,